Hey everybody, welcome to Active Self-Protection Extra with my friend James Reeves from the Firearms blog, and he is an attorney. So today on John's Briefs, I'm going to ask him a question I haven't prepped him for about, he takes questions, he takes calls from defenders. So let's ask him, what's the worst thing, the worst stuff he sees people do before they call their attorney in a defensive incident?
Now more than ever, you need trusted coverage to help you win the fight after the fight. The company I trust and recommend is Firearms Legal Protection. They offer discounts on all their plans at the link in the description. I recommend the premium plan.
So, James is a defense attorney. You get phone calls in 3 states from people who've just had a defensive use of force. And number one mistake you see people make.
I know you push this all the time, John, talking too much. You would think that as much as we push it in this industry, people talking too much, it wouldn't happen as much as it does. But I have a lot of times people who will at least spend the night in jail, if not say something that later becomes admissible in court because they're talking too much, whether it's on that initial 911 call, which, by the way, I always advocate that first call should be to 911.
Yeah, but it's admissible. That 911 call is recorded and admissible.
Precisely. And your second call should be to your attorney, and that's not admissible. And I want to hear the whole story. So I guess maybe a follow-up to that is I get lies. I get half. So
number one, you say too much to the cops, you say too much to 911. Number two, this one boggles my mind. You told me this last night, that people lie to their attorney?
All the time. All the time, because they feel like maybe for some reason they have to give you a better version of the story than what really occurred. It's attorney-client privilege. Tell me the truth, because what ends up happening is I'm going to be more aggressive with how I handle law enforcement, with how I handle your case if I'm sure that you're going to be innocent based on the details you've told me. But I'll find out, sometimes somebody will say, you know, John, I feel safe disclosing this anonymously, but
anonymously.
You know, I've had a case where a guy said, yeah, I shot a dog in self-defense. And then it's like, I'm calling the cops. I'm saying, why do you have my guy hemmed up? You know, when all he did, he shot a dog in self-defense. Well, what I find out is the guy didn't mention that he went and beat up his girlfriend, and they stuck the dogs on him whenever he's beating his girlfriend, and then he shoots the dog. So, technically he didn't lie, right?
Right. I mean, I shot a dog in self-defense
after you got done beating your girlfriend. Right. So why would you lie to me? Because now it makes me look bad, and I lose credibility. And the next time I call law enforcement, the next time I try to file a motion, they say, oh, this is the guy that lied to us to begin with.
Well, and listen too. What you say to your attorney is covered by attorney-client privilege. If you have an attorney-client relationship, that is not admissible anywhere. It's not shareable anywhere. So you got to tell your attorney the absolute truth and the whole story.
I don't know why you wouldn't. So it helps me plan your defense better.
Right. And listen, I get it. You go, well, maybe I'm ashamed of my actions, and so I don't want to do that. I get it. When we say you want to be careful who you say what to, that there's a couple people that have so much confidentiality that you can. Obviously, your spouse is one, right? That you have to say. Your attorney is one. Your clergy is one. As 15 years as a pastor, somebody tells me something that they did something horrible. They're not a danger to themselves or a danger to somebody else. A judge can say, hey, Mr. Correa, what was that discussion? And I can't tell you. It was covered by pastor and clergy privilege.
And that also varies state to state. So the privileges that vary state to state, spousal immunity. So it's like it very well could be that you might be in a state where one spouse can waive that privilege. So if your wife feels like telling you, you can't prevent her from doing that.
Right.
There are different rules that apply to different privileges in different jurisdictions. The one that remains perhaps the most untouched as it travels through jurisdiction is attorney-client. I mean, it really is, there's a sanctity to that, speaking of clergy,
there's a sanctity, there is that.
With your attorney, that is not going to be, only in the rarest of circumstances is there something that I'm required to disclose or that is discoverable. And half the time, if it's discoverable, it's a mistake that your attorney made.
Right, it's your attorney did something stupid.
Yeah, waive the privilege.
So, number one, they say too much to the wrong people. Number two, they say stupid things and lie to their attorney. Third biggest mistake you see people make.
Okay, and this is one that you and I talked about that I didn't realize was a mistake that some of my clients were making, and that is not carrying less lethal. What's the term you like to use, John?
You got to have something between a harsh word and a gun.
I like that. So
It's Chuck Haggard's term, not mine.
right, and we do get dog shooting calls. You know, like, hey, I shot a dog, or hey, I shot a guy, and maybe it was in the gray area of deadly force, like where deadly force was permissible. If you fall within that gray area, you very well may end up going to trial.
Right.
And even if ultimately you get cleared of those charges,
You got punished with the process.
yeah. I mean, we always say you can beat the charge, but you can't beat the ride. And you get punished by the process. And you go all the way through. So it was really eye-opening because I got to attend your seminar, which was incredible, by the way. Yeah, and not just, blowing smoke. Like, I really did enjoy that. And I talked to you right afterwards. I said, first thing I said, I really enjoyed that. Second thing, I was like, you know what? I need to start telling potential clients, because I do seminars throughout the state as well. I need to start telling them, carry something between a harsh word and a gun.
Yeah.
Because that would really, if instead of shooting a dog, like you shoot a dog, you're going to have to call the cops, or somebody's going to call the cops on
Right.
you. You may spend the night in jail. I mean, who knows, worst case
You're going to
scenario.
get a ton of scrutiny at least.
Oh, absolutely.
You
you're gonna
spray
catch
a
lot of
dog?
attention. You spray a dog, yeah, maybe you don't even need to make a phone call. I'm not even sure I would.
I've used those sea spray on dogs 3 times. There's a park in my neighborhood that I walk my dogs through all the time. Never called the cops one time.
Yeah, call the pound.
Put the OC spray away, head out, call animal control.
So I think that's something literally I learned 24 hours ago, and that's now my number 3, I would say.
Nice.
Yeah.
So got to help. Guys, listen. So three things. Number 1, watch what you say on 911. Watch what you say to responding officers. Let your attorney talk to the district attorney, right? So watch what you say. Say little. Number 2, tell your attorney everything.
Please.
Tell your attorney every bit of the truth, right? As soon as you've got an attorney-client relationship, you can tell them everything, and that is not admissible in court. And then number 3, carry a less lethal tool. And follow James and his team on the Firearm Blog. Good stuff. Thanks for coming on, man.
No, John, it was an honor. Thank you. I really appreciate it, guys. If you have any questions, feel free to email me, James@TFBTV. I answer them all the time.